very happy to have you guys here. Is this picking up? We'll record now. I'm Laura Hansen. I'm one of the reference librarians at UST Libraries, and I'm very excited to introduce to you one of our colleagues over at the University of Minnesota, Nancy Sims, who is a copyright specialist over there and is someone that we have been very privileged to hear speak at several library conferences and other events. And we thought we'd share your expertise because we know we all have copyright questions as we're doing our work around here at St. Thomas, and thought we could have her share some of her experience, some of her knowledge, but then also open it up to some questions that you might have about how that affects our work here. So without further ado, I'll hand the mic over to Nancy.
Thank you. I brought handouts. The likelihood that I will forget handouts when I'm traveling is like 50-50, so you're privileged to be receiving them. All right. So both Laura and Andrea had input into topics for today. And I always have a little bit of nervousness when I have less than 2 hours to start talking about copyright with people, because I find that less than 2 hours often means that people end up more confused than they were when they came in. So this is fairly narrow focus today. We're focusing specifically on copyright issues in courses, but there's also one other piece that's a little bit more about publishing. Just as a little disclaimer, let's see if there we go. I am a lawyer. I am not your lawyer. This is not legal advice. These are actually old school internet acronyms. Like this is early to Usenet days. People used to do this all the time. But if you are not that old of a nerd, then you might not be familiar with them. What that means is you are welcome to ask me anything, but there will be times when I can't actually answer the question because it would be saying, yes, you should do that, is acting as if I were your lawyer. There's also a couple of things where I believe from my conversations with my colleagues here that St. Thomas doesn't quite have an answer on a couple of points. There are lots of things where the University of Minnesota doesn't have an answer, but there's a couple of things where the University of Minnesota has an answer that St. Thomas may not have an answer on at the moment. So, a little bit of framing. Who is copyright for? Who are the beneficiaries of copyright? Any thoughts? The author. Copyright exists for authors, creators. Who else? Anyone else? Publishers. Society. Actually, there's one of those that I think is the correct answer, and it's that last one. And I think it's the correct answer for a lot of reasons, but let's talk a little bit. Copyright definitely benefits artists. It benefits performers, it benefits composers. He's the person who composes the music is probably getting some form of payment for it. Performers probably get paid for performing. Often people get paid for their recordings, and that's usually all related to copyright. And we don't tend to think of the person listening to the music as having any real benefits from copyright. She's not really involved in the copyright system here. We think of copyright as the lone genius of working his studio. He's building the new generation of visual arts. He's a beneficiary of copyright. But those of us who are going to museums to see the art, we're not really involved in the copyright system. The auteur making a film, and all the film crew, at least theoretically, are benefiting from copyright. But those of us who are watching it on our couches are just the passive recipients of copyrighted materials. Except, are we? When we watch TV, most people are fairly passive in their actual watching of video media, but how many people these days make new things based on the TV and movies that they're watching? Even if you sit around with a little kid for a while who's got a favorite movie and they're off playing, you're going to hear that movie in what they're playing. It comes back out again. So this person who's listening to music is benefiting from copyright even as a consumer. And she may also actually be somebody who's about to produce stuff. She may be doing ear training as a musician. This sort of idea that we have that there are people who produce and those are the people copyright is for, and there are people who consume and those are not really people involved in copyright. It's a really dominant paradigm, but it's not really how copyright works. She might be an artist. Many art students go to museums to sketch existing works, but even if she's not a visual artist, maybe she's a scholar of the arts studying particular existing works, maybe she's going to compose music based on all of these things. Copyright is not nearly as one-sided. Creators make things and they're the beneficiaries and other people consume and they're not, as we sometimes think. This is what the Constitution says copyright is for, which I'm sure you can all read. What it says is that Congress is given specific powers. Brief civics lesson: if the Constitution doesn't say Congress can do it, Congress can't do it. Most of the time Congress passes legislation based on the Commerce Clause powers these days, but intellectual property law, copyright and patent, actually comes from its own constitutional clause. Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. Whew. That's the basis of copyright and patent. And the really big thing for me in this clause is Congress has the power, by securing for limited times to authors and inventors, to promote the progress of science and useful arts. The actual purpose of copyright is a public interest purpose. We like giving authors benefits. That is totally part of this system. It is an intentional part of this system. But the author, the creator, is not the primary beneficiary of copyright. The creator or the publisher, who may often be a big beneficiary of the economic sides of copyrights, is definitely part of the system, is definitely an intended part of the system, because the idea is we give people exclusive rights to their works, and they will then profit from those exclusive rights for a while. And because they will have been able to profit from those exclusive rights, they will be more encouraged to make new works. If somebody else can just take your stuff and run with it as soon as you publish it, then you're going to think twice about publishing the next time. That's the idea of the intellectual property clause here. So really, copyright's this cyclical system. Nobody creates in a vacuum. Everybody who's making new work is referencing existing work, maybe just by reading it and having it come back out sort of subconsciously. But in academia, we all know it's actually often much more concrete than that. You're making new work because you are building on someone else's work, you are critiquing their work, you are taking it in a different direction. Often, you are both a creator and a user of other people's materials. In fact, very seldom are you a creator who is not also using someone else's stuff. And that's also true of those big content companies who would like us to think of them as producers. They are the producers. They make all the stuff. We really need movie studios. We really need music recording companies because they make all the stuff. They're not users. We're consumers. They make it, we consume. But all the stuff that they make is based on existing stuff. Disney is the easiest example in the world of this. All of the classic Disney animation that is based on existing folk stories. But go back several hundred years, you get Shakespeare, which has lasted up till now because lots of people like it for lots of different reasons. But almost every Shakespearean play you can trace backwards from when it was written. It was inspired by existing works. That's just how creativity works, as well as academic creation, artistic creativity. So that's sort of framing for everything here. Not everyone will agree that the primary beneficiaries of the copyright system are intended to be the public. Some copyright lawyers will tell you, by looking at that clause, to promote the progress of science and useful arts by securing for limited times to authors and inventors, they will say it's about benefiting authors and inventors. But I'm going to take that next step, vaguely political step, but it's there in the Constitution, and say that the progress is really the primary and the authors and inventors are the secondary beneficiaries. So, a little bit about your rights. How many of you are currently working faculty members producing either scholarly article-type publications or curricular material? Quite a few. Okay, not everybody. Different poll. For everybody, do you own any copyrights? Yes, open hand. No, closed hand. Come on, you can do it. Take a guess. Yes? No? Own any copyrights? Anybody who's doing this is wrong. And anybody who's doing that is wrong because copyright is completely automatic. As soon as you make anything that would count as a copyrightable work, there is a copyright and it belongs to usually you, not always you. So yes, you do own copyrights. And what you do with those copyrights kind of matters. Skipping a slide. If you create something, let's take it completely outside of the academic context briefly because university policy complicates things. If you create something at home, you draw a picture at home, you paint something at home, not part of your job, what rights do you own? What rights does copyright give you? If copyright happens automatically and you own it when you create it at home, what rights do you get? What do you get to say no to? No, you may not. Use it. Sell it? I think I heard somebody say copy it. Okay. Those are all definitely in the realm of copyright rights. There are a few more than these listed in the statute, but it roughly boils down to 4. A copyright owner has the right to control reproduction of their work. Copyright owner has the right to control distribution of their work, so that includes both sale and giving away for free. A copyright owner has the right to control public performance or display of their work, which is something that people sometimes forget about in academic campuses. This is a public performance or display. And a copyright owner has the right to control preparation of derivative works. Another one that's quite important for academic work. When you write an article and you want to include it as a chapter in a compiled work later, who owns the copyright matters quite a bit at that point. So if you create something at home, some piece of art at home, these rights automatically belong to you. They happen as soon as you create it. Oh, sorry, there's a picture I was going to point at here, but it used to be, so you may be thinking, copyright's automatic? I heard you have to copyright things. Used to be you had to register. Used to be you had to follow formalities. You had to put the little C in a circle and the year of publication and the name of the copyright holder. And if you did all that wrong, you could lose your copyright. That is no longer true. Hasn't been true for a while. Anyone want to guess when that stopped being true? 1970. 1970. Any other guesses? I usually hear somebody guess something about around when the internet got big. That's a big guess. You are the first time I've ever had somebody guess further back than it actually changed. So it changed in 1978 with when the 1976 Copyright Act took effect. And I know that some of you look younger than me, some of you look maybe older than me. For reference, I was born in 1975. So almost my entire lifetime, copyright has been an automatic thing. Now, it's automatic. Child painting on the back porch owns a copyright in that painting. Don't have to do anything, and this is why people sometimes get tripped up. You find something on Google image search, and they say, well, it doesn't have a copyright symbol on it, and I say, well, that doesn't matter, and hasn't mattered since 1978. Okay? As soon as the work exists, there is a copyright. You don't see the symbol, assume there's still a copyright. There's also lots of non-creator owners. And so this is where some of you who are St. Thomas staff may know the answer to this. If you create something at work at the University of St. Thomas, who owns it? University of St. Thomas. Even academic works like articles? Usually, most universities have some kind of a policy that specifies that because the default rule of law is that your employer owns anything that you create that is part of your job to create. If you think about like an ad agency, the basic rule of law is you do it at work, it's part of your job to do it at work, it belongs to your employer. Most universities have some kind of policy that addresses this point and confirms that faculty members and or some other people own their scholarship. And sometimes their teaching materials, but that depends on the school. So the University of Minnesota policy is that faculty and faculty-like people, which sometimes encompasses librarians, own their academic works, which does encompass teaching works. So St. Thomas policy would matter here. Let's assume we're talking about an article you wrote for work, but policy says you own it. Sound about right? roughly? Okay. How often do you keep the copyright in that article? See a little bit of a head shake. How often? Like you have a couple of different articles. Do you keep the copyright in those articles? Or do you give it to someone else? You usually transfer copyright to a publisher. Not always. This is where it really matters what your publication agreements say. And this is my main non-course related point. Copyright in academic articles almost always starts out belonging to the author of the article. Almost always. Not always. Federal government agency employees, there's no copyright. We'll talk about that later. And then people give it to publishers. And publishers then charge back to the universities to purchase and read it. This process is a little bit challenging. We've talked about this before. I actually found my slides from the last time I was here a few years back to talk about open access. I'm actually not going to push open access today, but what I am going to say is if you write an article and you transfer all the copyright to your publisher, you can't use that in your own courses. It's not yours anymore. A couple of people have gotten angry that Elsevier has taken down articles from academia.edu. Well, those articles do belong to Elsevier. The copyright was transferred to Elsevier. A lot of people have negotiated with publishers, which is why many publishers actually have policies up front that say, you give us these rights and you get to keep these. Or they have a policy that says, here's the transfer agreement, but then we have a separate web page that says, here's your rights over here. Rights that you keep in the contract, nobody can change without talking to you. Rights that are on another web page somewhere else, other people can change without talking to you, and they do. So if you want to be able to do various things with your own works, paying attention to the copyright transfer agreements actually matters quite a bit. And I have a lot, especially junior faculty folks tend to, or graduate students who I was talking to at Minnesota last week, I tell them, well, you can actually ask your publisher if they have an option that allows you to retain the copyright. And they go, I can't ask the publisher that. I need this publication. And I know. From within the system of promotion and tenure, you need the publication. You can't possibly negotiate. The publisher doesn't really care that much about the promotion and tenure system, and boy, do they need your articles. So you have some power in that negotiation system, not the most. There are times when I've heard of people asking for retaining some rights and not getting to keep them. The publisher says, no, we don't do that. And then the author has a different choice to make about whether they will publish with that publisher or not. But if you want to be able to use your article in your future book, if you want to be able to share copies of your articles with your students, or tell your faculty friends down the hall that they can share copies of your article with their students, you need to keep your copyrights, which is something that I suspect your library staff can help you with. So that is my non-course related point. Does anybody have questions about that? Before I take off, it's a little bit course related because it affects whether you can make copies for students. Yeah?
Say you write a dissertation and you write an article based on that dissertation.
Mm-hmm.
They only have rights to the actual article you wrote, not the study you did, etc.?
Oh, wow, that's actually a lot to unpack. If you write an article that is also related to other material you have published and you transfer the copyright in the article to one party, they only get the particular thing you wrote for them. The study, unless you've written it down, there's no copyright until you write something. So your research materials might have some copyrights, but and your dissertation will have a copyright, but the study, I'm not sure exactly where that would go in the world of copyright. In the US, pure data doesn't have ownership. So compilations of data can. That goes way off course really quickly. A related question to dissertations is often, I field a lot of questions from graduate students who are going to produce a dissertation and they have an article that they want to use as a chapter. They've previously published and they want to include the article as one of their dissertation chapters. Almost every publisher I have ever heard of allows that with no charge. but I have seen a couple of students who have gotten caught up in going to talk to a copyright permissions person first, and the permissions default is we'll find out how much it costs. And so I've actually met a student who ended up paying for something that they had published in the journal of the American Diabetes Association, I think. And when I went and looked on their website, they have a very clear statement that authors retain rights to use things for, not just for dissertation use, for almost anything. So pay attention to your copyrights. All right. Course use. This is the issue that most people at Minnesota will show up voluntarily for workshops about. I used to have a carrot, which was we had a required continuing education credit that people had to get every 3 years if they were a PI, and I could offer that if they came for copyright training. And they didn't want to come for copyright training about their publication rights. No! But they did sometimes want to come for training about course use. So when they discontinued the continuing ed requirement, this is the one thing people will still show up for. So I've got lots of good recent examples to talk about here. The first thing I want to focus on here, and it's on your handout as sort of things you definitely do, linking. The first couple of bullets here is, the world of copyright tends to look like this to a lot of people. No, 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 you can't do that. No, you can't use that. And when I said, what is, if you have a copyright, what do you get to tell people not to do? The first thing people said was use it. Okay, we're going to move away from the no's for a moment and focus on the yeses. So you can take away some definite yeses so that we don't end up with a brief period of conversation and you're more confused than we started. So yes, you definitely can link to things. Want to use a Star Tribune article, which I think I have a screenshot of. You want to use a Star Tribune article as a course resource. Link to it. And the reason I'm saying this is a super 100% yes thing is if you link to it, are you making copies? No. Are you distributing copies? No. Is it a public performance or display? And is it a derivative work? Linking to things raises no copyright issues whatsoever. I'll produce a caveat to that in just a minute, but in the US, linking to things creates no copyright problems whatsoever. So by this I mean share the link to the article in your course. You use Blackboard here, is that right? Put the link in your Blackboard, not a PDF of the article. I will admit there's a downside to this. That is what happens when the paywall comes crashing down. So it's not the ideal solution, but this is the 100% yes solution. I have had a couple of different people ask me, well, can I save a copy for myself? And then if it disappears later or if it becomes inaccessible later, then I can maybe think about posting it to my course website. In this case, since it has a print button on it, they have given you permission to print a copy. If they have a save button, which I'm not sure, I think it was under the more here, they have given you permission to save a copy. So if you're on a web page and they have these little tools that say print or save, they are giving you permission. This is not actually a legal license permission. This is what's called an implied license, but they give you the mechanism. They can't then tell you you were wrong to use it. So they are giving you a way to make a personal copy. You are definitely allowed to do this. It is less clear, although most people also agree that even on a web page that doesn't have a little save button on the page, your browser has a save button. Most people think you can probably save a copy of most web pages for personal, non-commercial research scholarship use. The File Save As button, most people agree, is actually probably legal. Otherwise, why would they not disable it? So I'm going to go with this is a definitely go ahead and save a copy, and then File Save As is a probably. Can't tell you for sure. What you do with that copy that you have saved for yourself is you wait until you cannot link anymore, and then you have a difficult copyright decision to make. But you have a backup. Similarly, with videos and stuff on YouTube, you can embed them on your Blackboard page. Embedding leaves the original file on the original server, right? So you haven't made any copies, you haven't distributed any copies, they're all still where they originally were. It has the same drawbacks. It's actually literally one and the same. You don't have to worry about copyright when you embed a YouTube video. YouTube has to worry about copyright, and they're doing it for you. They don't always do it very well, but they're doing it for you. So it may go down. It may disappear. That is actually part of the benefit of the embedding instead of copying. Saving copies of online videos is a little more complicated legally. I'm not going to go down that road. Digital Millennium Copyright Act, all kinds of things. Pay no attention to the buttons on my browser up there that would let me do that. Okay, so saving a copy of videos is actually more complicated than saving a copy of a text web page. But if you save a copy, you can make the decision later if it goes away. If you're using a video and it goes away, you can often find another copy of that video, especially on a different server. So not always, but sometimes. Yeah.
Maybe this is your caveat to make. So it seems to me like you can link to a lot of things that are up there that are violating copyright.
That is the big caveat. And this is one where I've slowly become more aware that a lot of people, I always say, if you find something online and you don't know if it's a legit copy or not, ask a 14-year-old. They're not good at deciding not to use things that are not good copies, but they're usually pretty good at determining what is and isn't a good copy. I'm fielding more and more questions from faculty members who find whole copies of books online and do seem to actually lack the skills to assess themselves whether that's a legal copy or not. So the kinds of things I strongly encourage people to think about is, just very briefly, is there any association with the publisher on the site on which you are finding the entire copy of the book? Is there any association with the author? Because authors often retain the right to distribute their work online. If you can't think, if you can't see and articulate a reason to believe this was posted by somebody who has something to do with the copyright ownership of the book, you probably shouldn't link to it. So the actual law on this point is about contributory infringement. It's all about, it has to be glaringly, obviously not a legal copy. And glaringly, obviously not a legal copy doesn't really have a very clear definition, but it's the kind of thing, don't link to a YouTube video that is clearly camcordered between the seats of a movie that's currently out in theaters. The idea is you are not making any copies or distributing copies or any of those things, but it's so obviously not a legal copy that when you tell people to go to it, you are encouraging them to use an illicit work. So look for connections to the people who produced it. If you don't see those, I would think twice about linking to it for a course use. That is a really good question. I don't have time to do the full-on how you assess whether something's a legit copy or not. I'm finding with online images, there are things that come to my mind that don't come to everybody's mind, but I've learned from other people some other tips. So it's something, again, libraries might be able to help with developing those skills. I know that faculty don't like to think of themselves as lacking certain literacy skills, but sometimes we are. I've learned a lot about guessing about whether something's a legit copy or not from younger colleagues. So, available online through your library? This is another 100% win. Just link to it. Link to it, not download the PDF and re-upload the PDF to your Blackboard website. Because the contracts for subscription access for libraries usually say that individuals related to the university can access the work, but they don't usually allow for redistribution of the work. And if you think about it on a very basic level, if you take the file off of their server and post it to Blackboard, they can no longer see the traffic. That's not exactly why they care about it in the contract, but that's one reason why they care about it in the contract. It's also a reason to think about for the libraries, at least at Minnesota. One of my liaison friends pointed this out to me recently. We decide what we are going to cancel when we get our budget cuts, which we always get. We decide what we are going to cancel based on usage. And those PDF files that people post to the course website are not things we can see in our usage stats. We see the one person who accessed it and downloaded it. We do not see the 26 students who clicked through on it. So if you are going to use subscription resources, you usually need to link to them, both because the contracts say that you should and because people do need to track the usage of the original. There are instructions on the St. Thomas Library website for doing this, and I hope they're the right instructions because I did put the link on the handout. Are these where you would want to direct people? Okay. This is not always easy. These kinds of links are harder to do than public web links. They tend to fail because it's usually routing through a couple of different servers along the way. So it may sometimes fail at the point of the student logging into campus resources, and it may sometimes fail at the point of whether the publisher believes we have access or not. Both of those can be failure points here. This is much better than it used to be. It works much more smoothly than it did 5-10 years ago. So things are getting better on this point. Part of the reason it remains hard is because people keep giving their copyrights to publishers. The publishers own the stuff. They want to control it. They don't want us to be able to make free copies of it, etc. If they didn't own it, if it was hosted elsewhere, it would not have quite as many access control barriers. Open access, woo! Yeah, any questions about linking to library resources? This is definitely something the St. Thomas Library staff can help with. Okay. Perform or display face-to-face in class. This is legally permitted under US law. This is really, really narrow, actually. Perform or display. Not make copies, not hand out copies. Perform or display. Not online, face-to-face in the same physical space. It doesn't actually have to be a classroom, it says, or other place devoted to instruction. But this is section 110.1 of the US Copyright Code. You are simply allowed to do this at a nonprofit institution. This does not exist for the for-profit institutions of the world. It's not like fair use, which we will talk about a little bit. In fair use, there's sort of a sliding. It's more likely to be legal if you're nonprofit, and it's less likely to be legal if you're for-profit. This is not fair use. This is a yes or a no, and this is a no for for-profits. What about an online environment? They tried to there's a section 110.2. Are y'all Teach Act compatible? Anybody? Yeah, no. Section 110.2 is useless because it was negotiated to death. It doesn't provide any of the kinds of flexibilities you need to respond to new technologies. For a few for-profit institutions who don't have this, who can't rely on fair use as well, the Teach Act has allowed a certain amount of putting things online. But for the most part, for putting things online at a nonprofit school, you're going to end up relying on fair use or permission. And we will talk about that more. So if you're in a synchronous session online, yep. So that's the classroom. Yep. Doesn't cover. This is not covering synchronous online instruction. It doesn't even cover. We actually still have a system at Minnesota, or did when I first started working there about 6 years ago, a dedicated telecom connection to our other campuses. Not an internet connection, not a public network connection, a dedicated line to do teleconferencing. That's not covered by section 110.1. 110.1 covers in the physical classroom. It's, as I said, real narrow, but where it applies, it just completely wipes out uncertainty. If you want to show a film to a film class, you do not need to pay anybody to do that. You put the DVD in a drive. Whoops. Do you have DVD drives available? The University of Minnesota is removing that equipment from classrooms because everybody has laptops. But everybody's laptops are now so thin that the laptops do not have drives. So there are layers to how annoying this is. But if you want a 100% certain way to show something to your students, do it in a physical space with them without scanning it, without ripping it, without streaming it, because streaming it involves the terms of service for your streaming service, all of which say it's for personal, non-commercial use only. Netflix, Hulu, all of those. So you can just show things to students in classrooms, but it's a pretty narrow just show things. I'm trying to hit the yeses first. We'll get to the maybes, and all of the online sharing is in the maybes. Yeah, Mary? Very good. Streaming that is purchased through an institutional subscription, usually the contract covers classroom use. It would be pretty ridiculous to pay for it if it didn't. But your personal subscriptions to streaming services. Is that actually hail? It's bouncing a little. Okay. In any case, this is somewhat useful in the higher ed environment, really important in the K-12 environment. There are a few other really specific exemptions like this. This is the classroom use exemption. You're just allowed to do this. There's some small business exemptions. You are just allowed to have the radio or TV on if you're under a certain square footage. Like, there are a few things that are just clear. Everything else is less clear. This is one that's sometimes useful for instruction. Making or sharing copies for reading or viewing. And this is where I'm into the whoa Nelly world. None of this is as easy as linking to public resources, linking to subscription resources, all the stuff we just went over, or the 110.1 showing it in the physical classroom. Everything after this is a little harder, but I'm still in the yeses. I'm still in the yeses for a minute. Okay, so the whoa Nelly. Okay, you got public domain materials. Does anybody care to hazard a guess what actually public domain means? It is a legal term. 50 years after somebody's death? What happens what does it mean for something to be in the public domain? There's no copyright holders. You can use it. My favorite framing of this is once this happens, once something is in the public domain, and for many things it happens because it's so old, once something is in the public domain, there's no copyright owner, which actually means we can all act like copyright owners. We can not just use it, but we can sell it. We can do anything we want with public domain materials. They all belong to everybody. If you think about things like those Penguin Classic books, those are like $5 a piece because they use really cheap paper and ink to publish things that they don't have any rights to, but nobody has any rights to. If you would like to scan your Penguins Classics book and put it up online for your class, you actually can do that if it's a public domain work. The age cutoff, can I borrow your handout for a minute? See if I wrote it down or not. I did not write it down. I will give you a link. The age cutoff, the one easy age cutoff, is published in the United States prior to 1923. Anything that was published in the United States prior to 1923 already belongs to everybody. Newspaper articles from 1918, go for it. Do whatever you want with them. You own them. Books published prior to 1923. So a few of the Anne of Green Gables books, but not the whole run. Some Shakespeare stories, Sherlock Holmes stories, but not all of them. Things that were published in the US prior to 1923 are in the public domain. There are many things newer than that are in the public domain. From about 1923 to about 1963, it's a good 50-50 shot that any given book might have its copyright already expired, because copyright ended. There was a long period when it ended pretty quickly. So 23 to 63, totally possibly in the public domain. That's where there's more things you would have to check than just exactly what date it was published. 63 to 78, still possible, but fairly unlikely. After 78, highly unlikely that it's in the public domain. The current term of copyright, if you create something today, lasts for... You're a ringer. Stop answering questions. 70 years after you die. You write something today, the copyright lasts for your entire lifetime and 70 years after that. In Canada, this is just because I mentioned the Anne of Green Gables books. In Canada, copyright has for a long time lasted for the lifetime of the author and 50 years after that. So you were totally right to be thinking 50 years. So in Canada, all of the Green Gables books became open at the same time because it's measured in the lifetime of the author. All of the Green Gables books are openly available in Canada. They are not openly available in the US. The fact that the internet goes swishy-swashy between the US and Canada means that you might find them online on a Canadian site for free. So they're technically not legal copies in the US. Age is a little tricky, but the 1923 cutoff is easy, and then there's lots of stuff newer than that that may be in the public domain. There's actually also some stuff older than that that may have copyright holders. Unpublished works don't have an easy cutoff. So there are unpublished materials from prior to 1923 that can still have a copyright. It's very technical. They would have to have been published in a certain window and blah, 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 but they, if they're old enough. This is a work drawn by Leonardo da Vinci. It is his version of Cleopatra. There is no copyright in this picture. It's way too old. But just to give you a sense of how weird some of the technicalities are, I wouldn't assume an unpublished work is in the public domain unless it's older than the 1700s. There are some things from the late 1700s that people have been able to prove probably still have a copyright in the US. Really stupid. As I said, it's a technicalities thing. It has to be a document that remained unpublished for a very long amount of time, but was published in a certain window and now has rights that attached at the moment of publication. Very weird, but if you follow the links for more information about the public domain, you will find charts that have like 23 footnotes that are how you figure out if something's in the public domain or not. And even those charts don't always give you an answer. It's pretty stupid, but sometimes worth the investment. There's also, questions in just a second, there's also a big chunk of the public domain that is not old. Anything produced by the United States federal government belongs to all of us as soon as it is created. This is why if you have colleagues who are researchers at federal institutions, they do not own any copyright in their research articles because nobody owns any copyright in the works of federal government employees. Everything NASA produces is all of ours to use. This is a little bit old, but not that old. This has produced some hilarious results on YouTube because, let's say we're Mars Curiosity rover, we do some video. NASA, like whole fun, entertaining line of questioning what happens to the copyright of videos created by robots, but let's not go down that line. Let's say NASA owns this video. NASA puts it up online. It shows up in news broadcasts. Those news broadcasts get posted to YouTube. Somebody else takes the NASA video and uses it in another way in another video they post to YouTube. The second user gets a takedown notice that their video violates the copyright of the news broadcast that was posted on YouTube because there's an algorithm that does the matching. And if you don't know to contest the takedown, this is something that actually happened. People whose commercial broadcast included NASA footage took down a non-commercial user's video that had no overlap other than the NASA footage. And luckily, I know about it because the non-commercial user actually knew this is not stuff that anybody has a right to control. I'm allowed to use it. You're allowed to use it. We're all allowed to use it. So one thing to think about with federal government works, they can sometimes include content produced by contractors. So just because you find something on a federal government website doesn't necessarily mean it was produced by a federal government employee. I think the reason I bring this up most is because when I first started talking about this with people, somebody said, oh, so if I find a picture on nasa.gov, I can use it. I'm like, well, NASA actually has so many cool pictures that they don't have stock photos, but lots of other Gov sites are so boring that they have tons of stock photos on them that were not produced by federal government employees and do belong to somebody. There's also the very interesting fact that the White House photographer, the official White House photographer, has a Flickr feed. And the Flickr feed says, you can use these for any non-commercial purpose that you want. And I sit there going, I don't think you get to say that. I think you're a federal government employee, and that picture belongs to all of us. But I don't know enough about the terms of the official White House government photographer's employment to be 100% certain that he's a federal government employee. I'm not sure about that. So that is public domain, not all old stuff. State governments can and do own copyrights. So just because something was produced by a government entity does not mean it's free for you to use. Other countries' governments own copyright. The Queen owns almost everything produced by state, national government in the UK and Commonwealth countries. Canadian stuff belongs to the Queen sometimes. Very interesting phenomenon. There's also a wonderful world of things that have a copyright, But the creators and or rights holders have already given permission to the world to use them. So I'm trying to stick with, we're out of the definitely yes because no copyright is involved, and into the definitely yes, copyright is involved, but there's a reason why you're allowed to use it anyway. So Creative Commons works. You have to own a copyright to grant a Creative Commons license. So if somebody were to, for example, scan a 1912 book and post it online and say, Creative Commons licensed attribution non-commercial, which is one of the more common versions. That means you can use it as long as you provide attribution and you use it for non-commercial purposes. That's an invalid Creative Commons license. It's a 1912 book. When you scan it, you own it, but so does everybody else. You are not actually allowed to license public domain works. You can create contracts. That's a whole other discussion. It is possible to end up as a user agreeing in a contract that you will not use a public domain work. So that can be something that libraries have run into from time to time. We will sign up for a collection of images, some of which are in the public domain, but the contract will say how we can and cannot use them. You may actually have signed up for something like that. If you download an ebook that is a public domain ebook, but it has terms of use, you might end up with contracts that control your use, even though copyright does not. But Creative Commons licenses are all based on an existing copyright. Every once in a while, even pretty smart people try to attach a Creative Commons license to something that doesn't have a copyright. So you do see museums sometimes attaching it to scans of two-dimensional works. Interesting wrinkle, in the US, an accurate reproduction of an existing public domain work, so a scan of a public domain book, etc., has no new copyright. In some other parts of the world, it does have a new copyright when you make a new reproduction. So sometimes Creative Commons licenses for really old things are valid. Most of the time, you don't need to worry about the details here. Creative Commons licenses are a way for someone who owns a copyright to say, I want you to use it, and to set certain conditions on your use. So I'm actually going to skip back a few slides just to show you how I use Creative Commons licensed images. Oh, no, I don't. This is from the US Department of Education. Never mind. Let me go back even further. This is an image that was posted online by somebody who said you can use it for anything as long as you provide credit. This is an attribution-only Creative Commons license. You can use this for commercial purposes if you want. So this is another one. This one has many more restrictions. This says you can use this as long as you provide attribution. You only use it for non-commercial purposes. And this is a share-alike clause, where if I were sharing this picture with the world, I would have to put a Creative Commons license on my work, which I usually do. So not a problem for me. There's more information in the handout and on the University of Minnesota website about good uses of Creative Commons materials. The question most people tend to have for me, especially academics, is how do I provide attribution? And Creative Commons doesn't care. It's any reasonable, appropriate attribution. There is some information on our website and elsewhere about the required elements of attribution under a Creative Commons license, because it has one thing that academics tend to forget. Academics tend to be thinking about citation in terms of we got to give credit to the author, we got to help people find where the original came from. So they're going to name the author anyway. They're going to usually name the work's title or provide a link to the original. The thing people tend to leave out is Creative Commons attribution actually requires a mention of the Creative Commons license. That's why my credits all say Creative Commons and mention the license. So people tend to leave that out. But when I say other than that, there's no specific rules, people kind of get uncomfortable and they try to get me to tell them how they should do it. Use whatever citation style you like, but you have to figure out a way to stick the Creative Commons license info into the citation style. This brings up a point I have not acknowledged yet, which is in the United States, there is no legal requirement for attribution when you use someone else's work. Creative Commons licenses create a legal requirement of attribution. This is why I actually think they may be particularly appealing for academic work, since people really care about getting attribution for their uses of their academic work. But if I make a copy of a public domain work, the picture of Cleopatra that I showed you, I don't have to give credit for that. There's nothing that says I have to do that. Academic ethics says I should do that. But even in the academic ethics context, we tend to think there are really clear rules. None of you would have noticed if I hadn't mentioned that was a Leonardo da Vinci picture. None of you would have cared. We feel very different about pictures than we do about figures from someone else's academic paper. So attribution is a very context-dependent, very norms and ethics-based issue. It is most of the time not a legal issue. Creative Commons can actually create a requirement of attribution. So that's a bonus as far as many people who might want to share their work might consider it. Okay, one last definite yes. Go get permission. I want to use this in my class. I want to be sure I can use this in my class. Find somebody who owns rights and ask them. The find somebody who owns rights is why I put the author in parentheses. If you know the author, ask them, that's great. But then also ask them if they retained copyright ownership, or you don't have to retain the whole copyright. You can retain the right to use it in your teaching and to authorize others to use it in theirs. That's actually part of a form contract that the CIC schools have put out as an option for their faculty members to consider when negotiating. So ask somebody who owns a copyright. Getting permission when you know the person is often free. Getting permission when you don't know them often involves the Copyright Clearance Center and often costs money. I don't know exactly how this process works here at St. Thomas. Do you have an office that does permissions clearances for course packs? I see some Mary going, no, 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 no. You don't have any central point that will get permissions for you. Okay. Do it on your own. Ooh, that must be fun. So the University of Minnesota, we're actually transitioning right now. We have a service to get permissions for our faculty members to use things in course packs. It has been run out of printing services for a long time because printing services have been making the paper course packs, but nobody uses paper course packs anymore. That's not true. There are still quite a few every semester, but they're going down. And we wanted to integrate it better with the library subscription resources. So it's actually moved into the libraries now, but we do. If you want to get a course pack put together, you have 5 readings, 2 of which are available through the library. So we can make those links for you if you give us enough lead time. I'm pretty sure that that's actually on the St. Thomas website. Course reserves. Usually the library can set up links for you if you give them enough lead time. Or we can, if you have a copy that you think is fair use, which is what we're going to spend the last bit of time here talking about, if you think it's fair use, we will host it for you, or sometimes we will encourage you to post it to Moodle yourself, or we will get permission for you. And permission usually costs money, and at Minnesota, it's usually transferred onto the individual student. So they have to purchase the course pack. If it's not centrally run here, how on earth is anybody recouping permission costs from students? I'm guessing not.
It hasn't worked for electronic.
Okay, so the bookstore can do for paper stuff. We've only recently been able to do electronic permissions for course packs, so that's a little bit harder. None of the people who sell that have good systems for doing that, except Harvard Business Publishing, which has some great systems for doing that, because wow, they need to be paid a lot of times. If you go to the Copyright Clearance Center, you will almost certainly end up having to pay for making your copies. I encourage people to decide if you need permission before you find out how much permission costs. Just in terms of helping yourself make ethical decisions, finding out how much it costs and then deciding if you need permissions, I think sometimes helps people make decisions that they don't need permissions when they might otherwise have decided that they did. So,
I think, isn't it go the other way? CCC will never tell you, oh, you didn't need permission for that.
That is also totally true. Another good reason to decide whether you need permission or not before you ask the Copyright Clearance Center. I have never heard a publisher, it's not true, actually some of the indie presses every once in a while say, oh no, don't worry about it. But none of the big academic for-profit publishers ever say, no, you don't need to pay for that. In fact, actually, if you go on like the Star Tribune website, they will tell you exactly how much it costs to download a copy for yourself, even though they have a button on the page that lets you download a copy for yourself. For many content owners, if you ask them how much it costs, they will tell you. And if you ask them if you need permission, they will tell you how much it costs, even for things where there is no permission required. Lots of film distributors will tell you you need public performance rights to show a film in a classroom. In my experience, about half the time, they don't even know about the classroom use exemption. They're not intentionally lying. About half the time, they are intentionally lying. I did once have somebody in one of my sessions, and I really don't know who this was, but they said, do you ask a barber if you need a haircut? The barber is always going to tell you you need a haircut. And that's do you ask a copyright owner if you need permission? They are always going to tell you you need permission. The Copyright Clearance Center actually has quite a bit of good educational information out there about things like fair use and when you need permission. But when you read things they produce, keep in mind that they have an incentive to tell you that you do need permission. They do overstate the case when they talk about permissions. Really good resources, just be a conscious consumer of those resources. Any other questions about these? Yes, link to it. Yes, use public domain materials. Yes, use Creative Commons materials.
Is there a good way of finding the Creative Commons materials?
There are a couple of different places where you can go to find Creative Commons materials. I actually do have a resource for that, like a handout type resource for that. It is unfortunately really segmented by media type. So there's a bunch of different places you can go to find images. There's a few places you can go to find music. I don't know of any really good places you can go to find videos in a central place that have CC licenses. Vimeo actually is probably your best bet for that right now, but they're not too strong on that. So, excuse me, for images, Flickr and Wikimedia are the best places. Google actually lets you restrict by Creative Commons licenses, but it's a little bit more complex. Flickr and Wikimedia usually have full information about the image file that tells you exactly why you can use it.
And how accurate is the Google search?
The Google,
It seems to bring up stuff that might actually
yeah. So the Google, like if on the advanced search in Google Images, you can now tell it to give you things that have reuse rights. It is better than it used to be. But there's two reasons why the Google search sometimes fails, and actually one of those spills over into Flickr as well. One reason why the Google search sometimes fails that doesn't spill over into anything else is that Google is searching web pages for pages that are labeled for reuse, and then they find files that are also associated with those pages. And their first iteration of this, any image that appeared on an HTML page where the HTML page had a Creative Commons license on it, the image was not marked as having a Creative Commons license, even though those are separate files and are not necessarily sharing the same reuse rights. They are much better than that now. The failure is not happening at that same point, but every once in a while, the images seem to be getting labeled as bearing a Creative Commons license when I can't figure out why they're being labeled that way. The other failure point is that people put things online and claim to be Creative Commons licensing them when they don't own the copyrights in the first place. And Google, by searching across so many more different sites, just finds more stuff with people who are making incorrect statements about rights ownership. Flickr has a little bit of the same problem. I do find things on Flickr where somebody uploaded them as an individual where there's no real reason why they look like they created it. It's pretty rare. I've very rarely encountered it on Flickr. I have never encountered it on Wikimedia because Wikimedia has built-in checks. Wikimedia also has lots of files that have other types of open licenses. They have GNU public documentation licenses, more complex system of licensing in Wikimedia. So little rundown of finding stuff. Music, CC Mixter. Other than that, no good recommendations for music anymore. There used to be a few more. But I can also send a link to some online resources for this that can be shared. So.
I was just going to mention real quick, if anybody has their published work in St. Thomas's Institutional Repository, all your work has a Creative Commons license on it. That's the one we use. That allows you to decide how you want to use.
We're the other way around. Everything that's in our institutional repository does not have a Creative Commons license. Even if you wanted to grant one, we don't have a system for supporting that right now. But that does bring up a very important point, which is the distinction between things that you find publicly online and things that you find online that have the licensing information attached. Because open access scholarship sometimes is just accessible sometimes is just like the Star Tribune website. And this is true for lots of things like open access journals run by Elsevier or run by the more traditional publishers. Anybody can get there, but it doesn't carry any extra rights to make copies or share copies with your students. Whereas PLOS, the Public Library of Science, the PeerJ, lots of the more new, innovative, open research publication venues do have Creative Commons licenses attached. That gives you the rights to make more copies and share with your students. And that is noted sort of in that handout as not all the time. Open access scholarship is not always licensed for reuse. Yeah?
Can you give a quick and dirty rundown on fair use?
That's what I'm asking questions now before we go to fair use. Because we do have till 5, right? Yeah, okay. You're welcome to leave if this is too long, but there's a question here.
Just one question for images you find in the public domain. Where is the difference? You can use it in your coursework, but if you want to publish it in a paper, and then if you want to publish it in a book.
So I'm going to refine your question. Images that you find, you said in the public domain, but I think you mean images that you find publicly available on the web. In the public domain would mean images that do not have a copyright. In the public domain, when you search Google Images, you find everything that's available online. Most of those have a copyright. When you find something through Google Images, if it doesn't have a Creative Commons license on it or it's not certified by some cultural institution as public domain, you actually can't just use it in your teaching. You maybe can use it in your teaching, and you maybe can use it in your blog post, and you maybe can use it in your book without permission. All of those are maybes. Those are all fair use situations. If you find something that's publicly accessible online, an image, a Star Tribune article, etc., and you want to make copies and give them to people, and putting a copy in a PowerPoint slide actually does technically involve making copies, you have to think about fair use. So what I've done so far is outline times when you either don't have to think about copyright at all, or copyright's an issue, but it's an issue with an actual clear answer. Fair use is the last bastion here. It's really important. It's what allows you to take images that you find online and put them in your instructional slides, but it is not a 100%, yes, go ahead, educational users, no, you can't put it in a book. You might be able to put it in a book, and there are maybe some times when an educational use might not be permitted. Question?
Probably really naive, but is this like when you say clip art about?
If you use,
Or clip art for groups or?
well, if you're on the Google website and you put in any search term, the results will include a box that says images, and you can click that to see images related to your search. Or if you go to images.google.com, you will be searching images to begin with. If you're asking for clip art, do you mean on Google's website or do you mean in Word?
I just put it in the box, clip art for whatever I'm looking for.
Is the box in a web browser or in, okay. In a web browser means you're probably searching Google. And clip art about is searching the entire internet. It is not searching things that are specifically licensed for you to use. So when you find something by searching for clip art about or images about, etc., the results that you are getting back are things where you should assume someone owns the copyright and you may need to think about whether you need permission or not.
And how do you find that out, or is that what you're going to tell me?
Well, I'm going to tell you about the deciding if you need permission or not. Finding out whether it has a copyright or not is a little bit more complicated than that. It's the default assumption you should make if you use a public web search to find images, unless you see the Creative Commons logo, the default assumption you should make is that somebody owns it, and you might need permission.
To what extent do you need to worry about the copyright laws of other countries?
To what extent do you need to worry about the copyright laws of other countries? Do you travel to those other countries? And do you have assets located in those other countries? I don't mean to be facetious. Those are the most important considerations as to whether you need to worry about the copyright laws of other countries. The university has a campus in Rome. If you're teaching through the Rome campus, you probably need to worry about Italian copyright law. If you are, and this is, I had a graduate student, this was a very hilarious interaction for me. The advisor and the graduate student separately contacted me about reproduction of images in an appendix to his thesis. And the advisor was very conservative, said, I'm sure he needs permission for all of these, you need to tell him that. And I'm sitting here going, it's not my job to tell him whether he needs permission or not. Let me outline for you the considerations as to whether he needs permission or not. Then I met with the student and I said, I can't tell you whether you need to or not. Here are the considerations. And he said, so what happens when I go back to my home country? And I was like, you're probably unreachable. And he's like, okay, I'm not going to care about it. I said, well, now you have to talk to your advisor about that decision, right? That's way outside of my purview. But I don't mean to be cynical about that at all. There's an entire field of legal study called international conflict of laws. The rules for whose laws get applied depend on what country you're in. In the US, we usually say that US law applies to uses in the US. Every once in a while, another country's laws will apply to a use that happened in the US. If you're in that country, they might say their laws apply, they might say US laws apply. It gets extremely nested and weird very quickly, and the internet makes it all much more complicated. So functionally, if you're doing stuff and it's online, there are times when other countries' laws might be relevant, but they can't really have much effect on you unless you are traveling to another country or you have assets located in that country. So that's not cynical. You do need to talk to a lawyer, especially if you do a lot of international travel and you have assets located overseas and you do a lot of ill-considered copyright things. It's also true that the US is the country, probably the country you are most likely to get a copyright lawsuit aimed at you. There's the people who have the resources to file those are here. Or in Europe. Europe has quite a few people who might file copyright lawsuits. Okay, so let's do fair use talk before we're all completely out of time, because fair use is going to leave you all confused. Sorry. I tried to give you the yeses. You've got the yeses. That's the not confused. You'll probably still be confused about fair use. This is what the preamble to the fair use section of the copyright law says. I like to highlight the actual text in particular to highlight that teaching, including multiple copies for classroom use, scholarship, and research, as well as criticism and comment, are written down as good things in the statutory law. I also like to point out that it says, is not an infringement of copyright, because there are people who do copyright education who tell you fair use is just a defense to infringement. Fair use is just legally allowed infringement. The legally allowed infringement thing, I don't really understand how they think that makes sense, because if it's legally allowed, it's not infringement. The defense to copyright infringement is actually technically true sometimes. And what they mean when they say that is that how fair use works in the law is somebody says you're infringing and you raise fair use as a defense. It's a procedural issue. Except that's not the only time you can raise fair use. People raise fair use on summary judgment, which is different than using it as a defense. And people are even using fair use in declaratory judgments now. So if you ever have somebody tell you that fair use is just a defense to infringement, you can tell them, 1, the statute says otherwise, and 2, Nancy says that's not true procedurally anymore. It used to be true. It is no longer true. Okay, so not an infringement. It is very squishy, however. So fair use is the jello of copyright law. This is why this will remain confusing after we've talked about fair use, because people can legitimately differ on whether they believe something to be a fair use or not. It's actually, from my perspective, from the perspective of most people who work heavily in copyright, the fact that it's squishy is a good thing. We have a lot of people, so this is one of the reasons I use jello as a visual metaphor here. Lots of people don't like eating jello. I get that. I do. Lots of people don't like operating in an environment of uncertainty. I get that. I have tried to give lots of ways that you can avoid the uncertainty. There are tons of ways you can avoid the uncertainty. The easiest and most direct one is get permission. No uncertainty there. Might cost money. But a lot of people would frame this as the flip side of uncertainty is our law is flexible. It's not the flip side. These are the same thing. The uncertainty and the flexibility are the same thing. We can anticipate new technologies through fair use. We don't have to wait for the law to be changed by legislators. Fair use is there to deal with new technologies. Fair use is also something that judges refer to very frequently as a First Amendment outlet valve. And if you'll remember, I highlighted criticism and commentary. You can copy from someone else's work in order to critique it. In fact, the more mean and nasty your commentary on their work is, the more likely it is to be fair use. If you are borrowing from someone's work in order to critique it, there's court cases where the Supreme Court has said, this is the kind of thing where the copyright holder is very likely to say no, and copyright does not exist to tell people no because you don't like what they're saying. Copyright exists to tell people no because you want to get paid and they won't pay you, or copyright exists to tell people no because you don't want anybody to use that work, but copyright does not exist to allow you to discriminate based on someone's viewpoint. And therefore, critical works, critical copying is highly likely to be fair use, partly because the rights holder is very likely to say no if you ask permission. So, fair use, super important for criticism and commentary. First Amendment values are frequently invoked when it comes up in court cases. It's also something that new technologies in the US are often reliant on. So the Google image scanning, the Google image results, which we were just talking about. Google makes copies of pictures in order to give you Google image results. There were three different lawsuits about that in the 1990s, and a court concluded that was legal, it was fair use. So let's talk a little bit about what you have to know to make your own call about whether something's fair use or not. You will be making a call that someone else will possibly disagree with. Every single time you make a fair use call, somebody else will be able to argue otherwise. You have to deal with the Jell-O. If you don't want to eat the Jell-O, don't eat it at all. Don't ask for me to give you hard Jell-O. Doesn't exist. Fair use with clear guidelines doesn't exist. Okay? You either deal with the jiggliness or you don't deal with fair use at all. So the law says these are the 4 things you have to consider. Don't worry too much about the details here. I'm going to break them down. But note that one of these factors is about what you're doing. The first one is about what you are doing. The other 3 are about the individual thing you are using. And this is why I will never make a blanket, every educational use is okay. No, you're only thinking about one factor if you do that. Sometimes these other factors might affect it. So what do these factors really mean? Well, none of these are, there's nothing where you can say, because it's educational, I'm done. And there's also nothing that's determinative, even on the purpose thing. So we're thinking about just one factor. We're still not going to have a clear answer, yes, factor 1 is totally on my side, or no, factor 1 is totally not on my side. That's why the handout that I gave you has arrows that are shaded. But like any number line that has arrows on the end, it continues conceptually. Fair use doesn't have clear endpoints of yes or no at any time. So things that favor fair use are educational purposes, nonprofit purposes, and purposes of criticism and commentary. Definitely know this. We know this from court cases that have dealt with this first fair use factor. Things that we know weigh against fair use is a commercial purpose. So this leaves us in an odd place for people who are for-profit educational providers. Fair use probably applies, but probably not quite as much as it does at a nonprofit educational provider. A lot of people tend to ask me about, did something happen to the projector? That just changed color. A lot of people ask me, so we're doing this thing, but we're generating revenue, so now it's not fair use. In classrooms, it is fair use, but we're generating revenue with this other thing, so it's not fair use. What do we think tuition is? Tuition is revenue. Activities at a nonprofit school almost always involve some level of revenue generation. So most of the activities at a nonprofit school are actually similarly non-commercial. Sometimes they will feel different, and feelings are sometimes as important as facts with respect to whether a lawsuit happens. So it may be that you're all in the same place legally, but your fundraising department decides not to rely heavily on fair use. That makes a lot of sense because people's feelings will be triggered more quickly that they should be getting paid when their stuff is being used for fundraising.
So fair use would include like continuing ed, executive education?
Certainly, that purpose would be a good one for fair use. But continuing ed, executive education, is that at some schools that's actually a different arm that's not nonprofit. I know some extended campuses, international campuses, are sometimes not nonprofit at the other end, so it does matter. And then executive ed would be another place where feelings might matter. If you're charging people $700 for a 2-day course versus you're charging people $700 for a semester, nobody pays $700 for a semester. What am I talking about? But a one credit semester-long course, generally, the economics look different compared to executive ed. So again, feelings might be triggered differently in those situations. Okay, so continuing with the fair use factors. That's the one factor that's about what you're doing. That's the one factor where what you're doing really matters. The other factors are all about what you're using. So the nature of the original work. Published works are more available for fair use than unpublished works. It's pretty straightforward. If I don't publish my diary and you do, that's not very fair. But it's very clear that the other factors all matter too. So there definitely are times when scholars can work using unpublished biographical material or something like that in order to write a biography of somebody who never published their diaries. It's not a slam dunk, definitely no longer fair use just because it's unpublished. It's just less likely to be fair use if it's unpublished. There's another part of the nature of the copyrighted work that starts out sounding easy. It's more likely to be fair use if it's factual, and it's less likely to be fair use if it's creative. So this is pretty straightforward to me. An illustration in a science textbook versus a fine art painting on a wall at a museum. Those are kind of distinguishable. One of those is maybe more available for fair use than the other. Then we get to things like documentary film, and we get to things like music based on pi, and we get to lots of things where this is not at all a clear distinction. For a lot of academic works, this is a relatively straightforward distinction. Most academic works fall more towards the factual end of the spectrum. They don't mean you're not doing creative work when you write an article. It's less of a creative work when you think about the types of creative works copyright law is intended to protect. Fiction writing, high art, fine art, choreography, theater, that's the kind of stuff that tends to be considered more protected. Not real straightforward. My favorite example of something that is totally unstraightforward to this is the Dance Your Dissertation contest that happens every year. If you've never looked for those, do. Students choreograph dances that explain their abstracts. Wonderful. Then they record videos of them performing it. Third factor, how much are you using? This is the one thing that most people have encountered before. The less you're using, the better. It's really, really straightforward. It is proportional to the work that you are borrowing from, and there's lots of bad information about this in the world. Anybody who tells you a hard number for fair use is wrong. If they tell you 150 words is fair use and more than that is not, they are wrong. Because there are times when 150 words is the entire work, and there are times when 150 words is a minimal portion of the work. It is a proportional measure. There are some times when percentage guidelines can be helpful here, but even there, if somebody tells you there's an always this much is okay and more than this is never okay, they're probably steering you very conservatively. The Supreme Court has approved things as fair use that copy the entire original work from time to time, in concert with other factors.
So there's never been a time when there was a hard and fast rule as to word count or something
Nope.
like that? Because in all the years I was publishing, I was told 300 words for prose work, 1 line for poetic work.
300 words for prose work, 1 line for poetic work, and this is really key. Your publisher may have a cutoff, and your publisher may even tell you that that cutoff is an interpretation of fair use, but it is actually an interpretation of what risk they're willing to tolerate. And I have seen that I haven't been in academia for that long. I mean, I worked in libraries before I went to law school, so we're talking like 15 years total. I've seen the numbers go down in the time that I have been working with people on issues related to their publishing. So the 300-word thing is now often a 150-word thing, and neither one of those is an interpretation of the law. It's we don't want to risk it, so we're going to tell you to get permission. this can be really important for a scholar who wants to use a work that doesn't have an existing rights holder. I can't prove it's in the public domain. I can't prove there's no rights holder, but I can't figure out who to ask. And my publisher says I have to ask someone. So they end up asking the library. And some libraries will give them permission. I won't. I will get on the phone with the publisher and say, there's nobody who can give you permission. Do you want to censor your author or not? Because the publishers can rely on fair use. They just pretend they can't. They do from time to time. So fair use does apply even for commercial publication. Sometimes they certainly can interpret it differently than a non-commercial use in a classroom. So let's keep going. Amount and substantiality of the portion used. I used to gloss over the substantiality because it doesn't come up in very many cases, but it did come up in one case really important to course use, which is this is the heart of the work question. Have you copied the heart of the work? And it came up in the Georgia State case, where Georgia State University got sued for book chapters in their online course system like Blackboard. And the judge, in the few cases where she said it wasn't fair use, which was like 3 out of 75, it was because they had copied the heart of the work and a large portion of the work. The last factor is really difficult to deal with. It asks you to predict whether your use will harm the market for the original work, which is great if you're an economist and you have access to the business plans of the company that owns the rights, but is a little bit hard for the rest of us. But the basic question is, will the copyright holders be out of sale or a licensing opportunity? And that or is actually a pretty important one. I have had people several times come to me with a book. We want to use this as a course reading. The only copies we can buy online are used, and the prices have gone up because lots of people want them. So it costs $500 to get a used copy. Can my students buy it and scan it and share it with each other? And I cannot tell you definitely that is a fair use if you can go to the Copyright Clearance Center and find out how much a license to reproduce it would be. Because the license, if you choose to copy it when there is a license available, you may be creating market harm. Even if there's no new copies available, the license is available, you may be creating market harm. It may well be fair use to copy some of that book. It may be fair use sometimes to copy all of that book, but I can't give you a concrete answer about when.
Is the idea of what, I've always heard, not always, but often, the one-time fair use.
Oh, thanks for bringing that up. The Georgia State case judge confirmed that has never been part of the law. It was in the classroom copying guidelines that were put together in 1976 by a group of educators and publishing industry people. The classroom copying guidelines were intended as at least this much is fair use. So they said at least if you find an article and you want to copy it for your students and there's no time to get new permissions, at least the first time you use it is fair use. Those guidelines sort of over time morphed into only the first time is fair use. They sort of slid from being the floor on fair use to being the ceiling, and those were never actually a statement of the law anyway. So the Georgia State judge, the publishers actually argued only the first use is allowed, and the Georgia State judge confirmed and was confirmed on appeal on this point. That's not true. If it was fair use the first time and nothing about the licensing has changed, it may well be fair use the second time. However, if it was fair use last year, but now there's a license, maybe you need to pay the license. So I know people will need to leave. Let me confirm the Georgia State case, because this is the most on-point law at the moment. It is not done. It is being appealed. We had a district court judge that confirmed fair use in almost every single book chapter posted online. Whole book chapters posted online were fair use in many of these cases. The district court got appealed. On appeal, the judges actually said, yes, many of these things are fair use, but you can't use rules as easy as the rules you made up. So be more complicated, basically. And so the appeals court said, yes, this is probably fair use, but you have to do it more case by case than this. And that's been remanded and is being appealed. Procedural stuff is weird. So there isn't an answer yet. Even if there is an answer on appeal, it still only applies in that circuit. It does not apply in Minnesota. It doesn't apply in Minnesota until the Supreme Court rules on it. There's no answer yet. It is certainly possible that that would go to the Supreme Court, but it totally depends on what happens on appeal. It's like the Google Books case and the HathiTrust case, which are also really important educational fair use cases. The appeals opinions on those are so solid. The Authors Guild is appealing those to the Supreme Court, but they are highly unlikely to have any uptake on that. The circuit court decisions are so clear and so well supported, and procedurally, it's in a good place to not make it to the Supreme Court. So I have no idea what will happen with the Georgia State case over time. We do not have answers yet about how many book chapters, how much of a book is allowed. And the Georgia State case will only resolve how much of a book is allowed, not how much of an article is allowed, or any of that. So you're still going to have to use your judgment on that.
It does seem like that case made people feel a little less timid about claiming fair use, though. Do you think that's right?
I think that case has had two contradictory effects. One effect is there are lots of people who tell me, I don't care what the law says. It's behind a password. I can do whatever I want. The Georgia State stuff was all behind passwords. If you are assuming that passwords are protecting you, don't. And for people who do say, I don't care what the law is, I would like them to be thinking a little bit harder about what the law is. The other end of things, the people who are afraid to rely on fair use, some of them seem to find the Georgia State opinions helpful. This is a court that said, yes, educational fair use exists. But some people are just so used to this fear mindset about fair use and really don't like the uncertainty that the fact that anybody got sued scares them more than the fact that the court said it was fair use. That's an unfortunate effect of there being people out there who are spending money intentionally to make educators afraid of fair use. That's not me being a conspiracy theorist. I can go point you at the resources. Very briefly, there is this other idea of fair use, and you don't even need that stuff. This is an evolving way people are thinking about fair use. It's probably not too relevant to classroom use, but it may be relevant to assignment use. If you assign students to take apart an article and put it back together in a new way, that may be legal as a fair use because it's a transformative use. This is an evolving doctrine. It's being applied more and more often. It was not really applied much in the Georgia State case, but it was applied in the Google Books case. And unless you haven't been paying attention, this spanned my entire legal career. Google got sued for scanning books from libraries. It's been a fascinating legal trajectory. District Court ruled it fair use. Second Circuit has ruled it fair use. It's on appeal, but highly unlikely to be taken any further. It was legal for Google to scan whole books and to make them searchable and to show you snippets of them, and they did not need permission to do that. This is also making people a little more confident about fair use. Even before the Google Books decision, HathiTrust, which is the research library copies of the Google Books copies, was confirmed as fair use for the same reason. And it comes down to it's a sort of a two-factor thing. Are you doing something useful and valuable, and did you use no more than you needed to achieve that goal? That's kind of where transformative use is going. We're over time. I don't want to keep you forever and ever. Thank you for coming. I hope you're not too confused. Too much